Well, so often, unfortunately, individuals are injured on their job site, whether a construction job site or it can happen in an office. And when that does occur, two words come up that often people are unfamiliar with, and that is workers' compensation. And basically, it's a system that almost 100% of the time someone's injured, they're entitled to workers' compensation. Now, in addition to that, there may be some kinds of accidents in which there is a so-called third-party action where someone other than the employer caused the accident that injured the individual. So our topic today is a very interesting and quite important one, and that is workers' compensation. And I'm really pleased to introduce a very special friend, and as well as a decade and a half practicing attorney in this specialized area. We're all part of a group working with workers' compensation. It's the Dearie, Donahue firm, and it's my pleasure to introduce Sean Reardon. Sean, what a joy to have you.
Thanks for having me here today, John.
Let's start with a question I'm sure you've gotten 1,000 times, and that is, so tell us, what is workers' compensation?
You answered the question perfectly, actually, in your introduction. Workers' compensation is there for people who are injured in the course of their duties. So any injury that you sustain while you're working and performing a benefit to your employer, you have the right to bring a workers' compensation claim. It was started in the early 1900s, and New York State was the first state to actually implement workers' compensation because, frankly, you don't have the right to sue your employer in most circumstances. So they started a new independent workers' compensation board where you bring a claim for benefits instead of suing your employer. Works in a much better fashion, so you don't have to have an adversarial position against your employer. Employers pay workers' compensation insurance, and they cover the injuries that you sustain in the course of your duties.
You've used that expression, in the course of your duties. What does that mean?
It means anytime that you're actually working. There's specific exclusions. Let's say you're getting coffee, you're on your lunch break. Very often, that type of employment injury is not covered for workers' compensation purposes. It is, in fact, a separate potential lawsuit, or there's no benefits flowing at all. But as long as you're in the course of your duties and you're actually performing, and the actual legal phrase is a benefit to your employer, you're entitled to workers' compensation benefits for the injury that you sustain.
So let's put an individual working, as I say, construction, office, or anything else, and is injured. What do you recommend that they should do?
Well, the first thing that they should do is notify the employer, okay? Obviously, you have to get medical treatment first, so putting that really as the primary concern. But once that medical treatment is rendered, it is absolutely necessary that an injured employee notify their employer that they've been injured, both orally and, if they can, in writing, okay? And they should do so within 30 days of the injury. More specifically, I tend to tell my clients, you get hurt on January 1st, you notify your employer that same day.
You did mention orally or written, essentially. Which do you recommend? And so a person is injured, and let's say severely injured, maybe breaks an arm or something like that, needs medical treatment right away. They're likely not going to be able to do it in your example on January 1st.
Sure.
But your recommendation is do it as quickly as possible after the accident.
Do it as quickly as possible after the accident. Obviously, writing a description of what transpired is the best way to do it. We also accept oral notification to the employer here in New York, but obviously we don't want to have somebody come back and say, he never told me that I was injured. It is best to both give oral and written. If I have a choice between oral or written, write it down. Tell somebody, write it down, explain what happened and the injuries that you sustained, and always cover head to toe. If you feel pain somewhere, it might not later be an injury, but certainly put down every place that you feel pain, because you don't want to simply 1 month later, now I have severe low back pain, but you didn't include that on your injury report because you thought it was a minor back pain at the time of the injury. Include it up front. Head to toe, do an analysis. If you have pain, put it down on the injury report.
I'm assuming that it's necessary for an injured person to explain how the accident occurred. And I'm under the sense that there is a certain cautionary word to an individual that they make sure that they tell the accident properly and correctly, as opposed to something maybe vaguer. less specific. Is that?
Well, I
that
try to be
concerning?
as specific as humanly possible in the C3 report. And the C3 report is your description of the injury to the New York State Workers' Compensation Board. And the reason why you like specificity is for exactly as you had mentioned before, a potential third-party suit. Maybe there is somebody else liable other than the employer for your injuries, and you're documenting right up front. And in workers' compensation and in other areas, we view this information as contemporaneous documentation, that you immediately remembered and told somebody what had transpired and what caused your injury. And that is very important for that suit and potentially other suits.
We're always talking in our face-to-face discussions with regard to statute of limitations. What is that time period when a workers' compensation claim must be filed, must be initiated?
It's a great question. The answer is 30 days to notify your employer. So that's step one. Okay?
That's fairly quick too.
It's very quick, especially if you're injured, you're not thinking about filing the necessary paperwork with your employer, you're just out on a medical treatment. You're less concerned about paperwork, you're more concerned with your health. It's very important to get that done. And if you can't, notify one of your fellow employees. Tell him, hey, listen, fill out an injured employee report, maybe stop by my house, I'll sign it, make sure it's correct, get it into the employer. Then there's a secondary statute of limitations. You have 2 years to file your workers' compensation claim.
From the date that
the date of-
injury or the date of when you file?
Sorry for stepping over you there. It's 2 years from the date of injury. Okay. So you have to have your C3 report into the New York State Workers' Compensation Board within 2 years of that injury.
Let's carry that forward. A person's injured, they file within the 30 days. What is the next step in time periods that a person would anticipate? The interaction with the workers' comp.
Sure. So you file the necessary forms with your employer. You file with the New York State Workers' Compensation Board. The very first thing that will happen is the insurance carrier that's covering your employer will give you a carrier case number, also known as a CC number. That's a very important number for your doctors. And your doctors will generally stop you from seeing them until they have that carrier case number so that they know they're going to get paid. Okay? So that's the very first thing, the contact that you're going to get from the insurance carrier. Secondarily, you're going to get a workers' compensation board number from the New York State Workers' Compensation Board. That identifies that you now have a claim from them. The insurance carrier can do one of two things at that point. They can accept your claim and start paying you your weekly benefits, or they can deny your claim, in which case then we're going to have to proceed to court, go before a judge, a workers' compensation law judge, and they're going to have to establish your claim. Okay? And generally speaking, the insurance carrier will send you out for what's known as an independent medical examination, or an IME, by one of their physicians to determine the severity of your injuries and whether in fact you do need to be out of work, as your doctors are seemingly saying.
In the general course of things, not a specific case, but generally speaking, from the time a person is injured and they do their filing, what is the time period that they would reasonably expect to start to get some payments from workers' compensation?
Well, hopefully the next pay cycle. Okay, so if the insurance carrier is accepting the case, you're going to generally, so there are some positions in the public employment sectors that you continue to receive your full pay based on what's known as General Municipal Law Section 207C. That covers them for full pay. Okay, for just about everybody else, you will immediately be notified by the insurance carrier, we're issuing you a check, or we're not issuing you a check, we're going to controvert your claim. If they controvert your claim, right now in New York, you're probably going to go several months before we get before that law judge and he issues a determination that you're entitled to benefits. So it's very important. That's why that contemporaneous documentation becomes so important, because you notified your employer, an accident happened, I sustained injuries, I saw doctors, I got the medical records into the comp board, insurance carrier will probably pay. But if you're missing any of that, very often they're going to controvert the claim.
On balance, out of 100 filings that may take place, and let's assume the filings are reasonably comprehensive and on time and so forth, of those 100, how many would you say on average would get paid within the next pay period or shortly, as contrasted to those that would be denied by an insurance carrier?
It's an interesting question. I've never run the actual numbers, but I would tell you probably somewhere in the ballpark of 30% are probably going to be denied just because the insurance carrier is going to question whether an accident actually did take place. And 70% who did their paperwork right, they're going to proceed right into a workers' compensation weekly benefit.
Once a person begins to receive their benefit, what is the time period that they can continue to receive that benefit?
Sure. No, that's a great question. So really, workers' compensation boils down to two types of different compensatory actions. The first one being what's known as scheduled loss of use awards, okay? And those are injuries to your extremities, your arms and your legs. And then there's really spinal injuries as well. So spinal injuries pay you while you're out of work, okay? So you injure your neck or your back, you're only going to receive workers' compensation during the time period that that specific injury keeps you from working. Whereas if you injure your knee, your shoulder, your arm generally, or your leg generally, you're going to have a period of time where you're out of work based on that injury, but then perhaps you're going to be able to go back to work. That benefit, that weekly benefit, will stop. However, there is compensation on the back end of that claim for the injury that you sustained. And that's known as a scheduled loss of use in New York. So the doctors will decide, based on your injury, what percentage loss of use you have under the New York State SLU guidelines, and they'll issue a determination for your scheduled loss of use, both your doctor and the independent medical examiner for the carrier.
In New York State now, what is the maximum benefit an individual can receive given an injury?
Sure. So right now, the average weekly wage maximum benefit is $870.61 for 2017. And actually on July 1st, it's going to be raised to $901.74, I believe is the exact number. So significant increase, and it adjusts every July based on what New York State gauges as the new average weekly wage for the average New Yorker.
Let's go back to that individual who was denied by the insurance carrier. You said it may be several months. Does that involve hearings with workers' comp? Where are those hearings? How long do they take? And generally speaking, if an individual has been denied, what's the likelihood of reversing that and ultimately getting workers' comp?
Also, another great question. So let me take where they actually transpire first. Workers' compensation has regional offices throughout the state. So really, whatever county or borough that you live in, there is going to be a hearing office located in that specific borough or county. And that's, generally speaking, where the hearing will be held on your behalf. So that's number one. If you're denied benefits, yes, we're going to proceed to a law judge, probably on several occasions before the judge will lift and order the carrier to begin payments. But certainly, the overwhelming amount of controverted cases are subsequently overturned by the judge and benefits are issued.
How would you classify the general type of injury? I know it goes a very broad spectrum, but based on your years of experience, what does seem to be the categories of injuries?
I think probably the most prevalent injury right now is the back and or neck injuries. Obviously, we deal with a lot of construction unions, police unions, guys who are in heavy occupational titles who just by mere lifting or lifting on the job in a construction site or restraining an individual while effectuating an arrest, they injure their backs. That's probably the largest category of injuries at this point. Shoulders, knees, elbows, wrists, carpal tunnel, occupational disease claims for repetitive traumas. So maybe you didn't sustain this particular accident, but you know what? I've done 25 years of heavy lifting as a laborer. Certainly, you're going to sustain back injuries during the course of all that lifting. That's what's known as an occupational disease claim. And even though you didn't have one particular accident, you can certainly bring a workers' compensation case for the occupational disease.
When we have represented individuals that have had some type of a case that lends itself potentially to workers' comp, I have found that a fairly substantial number know of something called workers' comp, but do not know that they're entitled to it. what is the entitlement aspect of it, and is it fair to say virtually everyone who is injured in their work is entitled to a workers' comp? And what has been your experience in terms of people today versus 10 or 15 years ago understanding of their entitlement?
I don't think it's actually gotten much better. That people actually understand what workers' compensation is and that they are entitled to it if they are injured in the course of their duties. Unfortunately, I think as an industry, we probably have done a bad job of really getting it out there in front of people and having them understand it a little bit better. Most people think of, I get hurt, I sue. That's the type of personal injury action that they want to bring. But instead, it's really a workers' compensation. So I don't think that the information is generally well known out there that workers' compensation is applicable to really, as you said, anybody that gets hurt in the course of their duties. I mean, if you were injured at work, 99.9% of the time, you have a workers' compensation claim. Whether it's a small claim or a large claim, you should put it in. And again, you're not suing your employer. I hear constantly still to this day, well, I don't want my employer to be mad at me. No, your employer pays workers' compensation insurance for this protection. There should be no adversarial process with your employer simply because you file a workers' compensation claim.
Has it been your experience there are some situations where employers take a negative, if not hostile, sort of attitude towards an employee who may in fact file for workers' comp? Or inversely, have you seen situations where the employer says, don't worry about it, I'll file for you, and they don't do it as aggressively necessarily as, let's say, an independent attorney like yourself would be more aggressive in terms of pursuing their workers' comp benefits?
No, sure. So the first part is, I would say, I wouldn't be naive enough to say that the employers don't sometimes look at workers' compensation in an adversarial way. And that's because I don't think that they quite understand exactly what workers' compensation is. They try to involve themselves in the process when really the insurance carrier should take control. Certainly, the more claims you have as an employer could affect the premiums that you pay, but there really shouldn't be a reason not to continue to employ that person or create a hostile work environment for them simply because they filed something that they're entitled to. In terms of the secondary nature, yes, unfortunately, you hear all the time one of two scenarios. Oh, I'll file all the paperwork for you. Don't you worry about it. Or number two is, oh, no, listen, I'll take care of the hospital bill and I'll give you $500 or something to take care of your injury. And people expect, A, that the individual, the employer did in fact file the paperwork, never did, and now we're outside that statute of limitations that you and I spoke about earlier, which now it's missed and there's no documentation of the injury ever happening. And second, contrapositively, is you take that guy's $500 under my hypothetical, again, what is missing? He's probably not going to say that an injury ever took place. Probably going to say that he never paid you a single dollar. And by the time you file your workers' compensation claim to try to seek some sort of benefit out of this, whether it's your health care bills or otherwise, there's no claim to be had because you missed your statute of limitations. It's a continuous big problem in the workers' compensation arena.
Someone is injured. If someone is in an automobile accident, for example, then the question is, did the other driver hit them from the rear, hit them from the side? Someone had a crack in front of their sidewalk and the person tripped and broke their ankle. Someone has to do something wrong. It's called fault, as we know. Sure. So my question is, if a person is injured, must they prove that someone did something that created the condition that caused the injury? Absolutely not.
It's a no-fault system, workers' compensation. So we don't look at anything other than, are you injured? Do you need workers' compensation because you're out, or do you need health care benefits? The only really exclusion to that is if you were drunk and or on drugs, that is an exclusion. Other than that, your own misstep or even your own negligence does not preclude you from receiving workers' compensation benefits.
Two parts of a question: if someone is injured as a result of a death. One of them is, if a person, let's say, and we regrettably hear this, falls from a building and to their death, is a workers' comp available to them, and as importantly, to the spouse or surviving family?
Sure.
And the related question is if someone is an undocumented individual status, are they still entitled to workers' compensation if they're injured?
So The answer to that question is, if somebody were to fall from a building under your hypothetical and subsequently, unfortunately, pass away, yes, there are benefits payable to any widow and or children. Okay, so there are death benefit claims under the workers' compensation system, which would allow them to recoup benefits really for the widow until she remarried, and until for the children up until the age of 18, or if they're subsequently in college, they can receive benefits through their graduation from college. In terms of the undocumented status issue, yes, we absolutely cover undocumented peoples here in the United States for workers' compensation, and quite frankly, rightfully so. Those who are injured in the course of their duties, regardless of immigration status, should receive workers' compensation benefits for the injuries they sustain.
One final general topic, and that is that there's been some efforts on the legislature in Albany with regard to workers' compensation over the last couple of years. And I know that we've gotten many questions about it, and you must get deluged with them. So what is the status? Are there going to be big changes legislatively in terms of Albany?
Well, luckily, we've kind of thwarted any major changes last year in 2017. We were certainly facing some dramatic changes in the workers' compensation system, specifically to those scheduled loss of use injuries, to the extremities, the arms and the legs that I had referenced earlier. Really, the Workers' Compensation Board had come up with a whole new way to calculate those injury payments under what's known as the SLU guidelines here in New York. Those were stopped by the legislature and by the governor. The new guidelines came out in December, and they made only minor changes, which was an excellent thing for the legislature to do, put pressure on the Workers' Compensation Board to really look at what they had come up with and told them this is not going to properly cover the injured workers here in New York and compensate them for the injuries that they sustain. So great job by the New York State Legislature at that front. And we're not expecting any major changes now. Obviously, every year there's a few bills on workers' compensation that go before, but I don't see anything major on the horizon. We were very lucky to stop last year's major changes from going into effect so that injured workers can really get the just compensation they deserve.
When an individual believes they've been injured, and in fact have been injured in a job-related accident, I'd like to give them to be in touch with a person of your experience and background. So might we recommend that they be in touch with you at
any time? Please give them my number, and feel free to reach Dearie Reardon Donahue at any time. If you have any questions, concerns, issues, you think you might have a claim, you might not, just call. It's a free consultation. We'll talk to you about your rights and what actions you need to take.
I said at the outset that we had someone with an awful lot of experience in this very important area, and I think you just proved that. So my thanks to you, Sean Reardon.
Thank you, John.
And I have no doubt that those of you who have watched have learned something from this, and that's the whole purpose of our face-to-face conversations. Thanks very much.